Good morning, everyone. First of all, I would like to introduce myself. I am Ester Renedo, professor of administrative law at the University Isabel I de Castilla in Burgos, Spain. After spending a week in Lisbon with Professor Vasco da Silva, he proposed me that challenge to participate in the LP's program to talk about the global European and national courts in search of a multi-level rule of law. For me, it was a real honor, and I accept Professor Vasco challenge. So, in this challenge, I'm going to talk about the jurisdictional problem that exists in environmental criminal law. First of all, I'm going to talk about cooperation in criminal matters as a system of the mutual recognition of judgments. We will therefore further analyze that environmental law is and which areas on the legal system it affects. Environmental law is a branch of law and in which both administrative law and criminal law, among others, coverage. Therefore, we could define it as the set of legal rules that regulate human behavior that can directly or indirectly alter the environment and that aim to prevent and remedy the disturbance that alter its balance. Environmental law is understood to include not only the rules and their study and interpretation, but also the body of knowledge that comes from other non-legal environmental sciences, such as biology or geology. The environment in the Spanish legal system is a guiding principle of social and economic policy and stated in the Article 45 in the Spanish Constitution. And at the end of this article, it said, based on the indispensable collective solidarity. Those words, collective solidarity, will be the key to how the different states will have to proceed when applying and regulating environmental law. For this reason, judicial cooperation in criminal matters will become a necessary requirement. Judicial cooperation in criminal matters is based on the principle of mutual recognition of judgment and judicial decision and includes measures to harmonize the law of states in various fields. In the case of European Union and its member states, based on the provision of Articles 82 to 86. They have been given a more solid basis from the development of the area of freedom, security and justice, while the European Parliament has been given new powers. The next point, we have to talk specifically about the environmental criminal law regulation on third generation rights. In environmental law, in its criminal aspect, we can observe that the subject who commits offense against the environment can be both natural person and legal person, which make the prosecution of this offense much more complex. Then, if we analyze this aspect of the commission of attacks against the environment, we can observe that they have similarity or certain similarities with the structures of attacks against human rights. In this similarity, that needs to be emphasized. Attacks on human rights led to the creation of the International Criminal Court in 1988. The similarity between these attacks is based in two elements. On the one hand, society, specifically in Western society, is largely aware that environmental protection is a global task. The effective protection of the environment cannot depend solely on the ability of the state to implement legislation that prosecutes attacks on the environment and the infringements resulting from such attacks. This is a very loose assumption as the exciting discrepancies between the states, even within the state, do not allow for global homogenization. We can see how the member states of the European Union have regulated environmental protection in different ways in their legislation, despite the existence of framework strategies or EU directives that take them along a common path. Countries with greater environmental sensitivity, such Germany, have stricter environmental regulations, while other countries, such as Hungary, have laxer environmental regulation. This presents a serious problem in environmental regulation, and these countries, as part of the European Union, they belong to be a supranational organization. So, what about all the third states that are not covered by European law? What is that homogenization can be achieved in terms of human rights. Just as the sanctioning of human rights violation cannot depend on the will or efficiency of a country's judicial system. The most serious environmental violations are no longer a national matter, but a matter of global governance. Therefore, if we understand environmental law as a third-generation law similar to human rights, it is clear that there is a clear similarity between the two, which is why it will be reasonable that in the medium of short-term international organizations should chat about creating an international criminal law of the environment, with the establishment of even a supranational court to punish these crimes and deal with environmental issues. The urgency of renewing environmental law will have to take one of the following paths. The first of these will consist of the creation of common regulations, the result of a process of harmonization between the legislatures of the different states, which will require the creation of common criminal offenses in which the rules of international environmental law and international convention of criminal matters, such as the European Union Directive of the Council of Europe Convention, will be included as a reference point. The second path to follow will be the determination of collective liability and environmental compliance. So if together with individual liability, the liability of legal person is called for, as this line of liability was not included in the Rome Statute. The hypothetical international environmental law, what could be the criminal offenses? To develop an international environmental criminal law, as mentioned in the previously, the hypothetical criminal offenses will be based in two pillars: collective responsibility and the structural similarity with crimes against human rights. The prevailing need to dissociate within environmental law international crimes for administrative regulation means that neither the EU directive, which refers to the protection of the environment in criminal matter, nor in this case the Council of Europe Convention can be modeled for future international criminal law. These standards, the EU directive and the Council of Europe Convention, are two of the most relevant examples of international standards and cannot serve as a reference as harmonized legislation, thus making global harmonization in this area difficult. The EU directive is clear on environmental offense as it links them to a violation of the EU's own environmental legislation. Therefore, all behavior that is sanctioned in the directive must be in breach of the law. The same applies to 4 of the 5 types of behavior referred in the Council of Europe Convention. Only the first of these is dissociated from the infringement of any environmental regulation. If environmental criminal law were to rely exclusively on individual responsibility, as in the statute of the International Criminal Court, corporate actors would be responsible for the operational failure that lead to the environmental damage, as the Bhopal case. Some of the theories that have been coined in this field, such as perpetuation by means through organized apertures of power, the redefinition of co-perpetration or commission by omission, are in principle the theoretically possibly to apply to some cases of crimes against the environment committed by multinational companies. Although international environmental law has not developed to a degree like that of human rights, there are some basic consensus on which criminal law intervention can begin to be structured. These 5 standards are: the first, we can compare environmental violation to first-generation human rights violations. The second, understanding environmental damage as possible economic damage that affects the exploitation of natural resources. The third, the sanctioning of environmental macro damage. The fourth, the recognition of environmental damage to first-generation human rights violations. And the last, the prosecution of transnational crimes or damage against the environment. By linking human rights violation with environmental law, such as torture, genocide, crimes against humanity, we can see that this comparison or linkage can lead to the cessation of environmental sovereignty, which is based on the ownership of natural resources. For this reason, the proposal to link environmental damage to international criminal law constitutes one of the most studied environmental crime, which is still at an experimental stage, namely ecocide. Ecocide is a criminal offense that the doctrine began to formulate in the 90s, and it consists of the accusation of malicious environmental damage with the intention of wiping out an ethnic group, race, or indigenous community. A prototypical example of ecocide will be that of the multinational oil company, whose exploitation clashes with the interests of a small indigenous community and which decided to wipe it out by poisoning the drinking water. Ecocide, as an international crime, would evolve and constitute a precedent that would make it possible to claim the distinct jurisdiction of the International Criminal Court and carry out a reform of the court statute. A reform of the International Criminal Court statute would be going beyond that happened in Nuremberg, contemplating situations to go beyond behavior committed in the context of war or armed conflict. This idea really is already present in Article 8.2 that say which state that in its war crime to launch an attack intentionally with knowledge that it will cause widespread long-term and serious damage to the natural environmental, which is clearly excessive in relation to the military advantage sought. Even though it is already regulation and it only remains to be implemented and extended, it has major shortcomings for the current situation, as can be seen, for example, in the resolution issued by the International Criminal Tribunal from Rwanda. Despite all the environmental damage resulting from that conflict, the environment is not mentioned once. In fact, if we analyze its resolutions, the International Criminal Tribunal for Rwanda, to keep in line with Article 8.2, only obliges states to take into account the protection of the environment, assessing whether the damage is proportionate and necessary for the achievement of a militarily legitimate objective. Therefore, the creation of this environmental law is intended to include it among human rights. Its core will deal with all damage of a transboundary nature and the traffic of natural goods, such as traffic of protected species, live animals or plants, traffic of dangerous substance, or trafficking of waste. Examples of this incident harmonized environmental criminal law, for example, the International Convention for the Prevention of Pollution from Ships, the MARPOL, whose function is to prohibit pollution discharge from large oil tankers, which requires de facto that the infringement be criminally punished by the signatory states, similarity through customs offenses, smuggling, or environmental crime. Member states often already provide extensive protection for protected species in compliance with the Washington Convention on International Trade in Endangered Species of Wild Fauna and Flora. The same applies to trafficking in waste, the Convention of Permanent Organic Pollution, and the Article 4.3 of the Basel Convention on the Control of Transboundary Movements of Hazardous Waste and their disposal, obliges signatory states to make illegal transboundary traffics in hazardous waste of criminal offense. In the specific field of international criminal law, the most important project is the Draft Code of Crimes against the Peace and Security of Mankind, which aim to extend the crimes of international law beyond those provided from in the Nuremberg Charter. Article 26 of the Drug Codes contains an offense called international and serious damage to the environment, which punishes whoever intentionally causes or orders the causing of serious, lasting and widespread damage to the environment. This brief review of the various proposals for international environmental crimes has shown that there are 5 different approaches to criminalizing this offense. The first of all is ecocide, which I talked before, in which damage to the environment will be the instrument to exterminate a race or an ethnic group, or based on the proposal of cultural genocide to deprive an indigenous community of its ethnic or cultural identity or to provoke its forced displacement. The second one, geocide, which would include widespread and long-lasting damage to the environment, carried out intentionally or negligently without any economic or social justification, and which, because of its magnitude, has an international dimension. The third, patrimonies, will refer, in addition to other conducts, to the plundering of natural resources because of act of abuse of power, either by the leaders of a country or by multinational companies. The fourth, the offenses of illicit traffic relate to the environment, which would involve waste, protected species, and dangerous substance. And the last, the serious transboundary environmental crime, which would cover those cases in which the damage to the environmental seriously affects, either through injury or concrete danger, the health of life or several people in another country. Within this group of definitions, we can make a double classification. Firstly, the crimes of ecocide, geocide, and patrimonies will be subject to the principle of universal justice, and the International Criminal Court will have jurisdiction over them if its statute is reformed or a newly created International Environmental Court that has the legitimacy to judge this type of crime. Secondly, transboundary environmental crimes, which would operate as harmonized international criminal law, could be judged in accordance with the principle of territoriality and the active personality principle in such a way that the member state of nationality or resident of the perpetrators of the crime would also have jurisdiction of if collective responsibility is admitted. These are the 2 ways in which environmental crime can be prosecuted. In summary, to solve the multi-level problem that exists over the different jurisdictions, I propose these solutions. The first one, the consideration of the environment as a human right. The second one, the creation of 5 new criminal offenses. The third, the creation of an ad hoc court to try only environmental crimes. And the last, the amendment of the statute of the International Criminal Court, so that collective responsibility is also included on it. Without further ado, this is my brief presentation. I hope you enjoy it, and I would like to thank Professor Vasco once again for inviting me to participate in this program. Thank you very much, and see you soon. Bye.